If you've ever wondered what are the steps in the mediation process, this video will provide you some answers. So if you're like many, mediation feels like a mysterious black box. You know it's a process by which parties come together to resolve their disputes with the help of a third party, neutral, called a mediator. But that's really all you know. If you want to peek under that box just a little bit more and learn what mediation is and how it works, stay tuned. In this video, I'm going to walk you through the basic steps of a typical mediation process from start to finish. But before we get to the steps of the mediation, let's take a step back to talk about what is called the intake or pre-mediation stage. Before parties show up in a conference room or on Zoom to mediate, someone has typically referred them to a mediation. Sometimes it's a lawyer or a family member or a friend. Sometimes one of the parties has heard a bit about mediation and so has taken the initiative to reach out to the mediator. This initial pre-mediation phase, often called intake, is the entry point to a possible mediation. And in this stage, the mediator will ask some really basic questions about the conflict. Questions like, who are the parties? What are the issues? What has made resolution elusive so far? And what might a good outcome look like for the various sides? You can almost think of this stage as a diagnosis. A mediator is taking the temperature, pulse, heart rate of the conflict to get a sense of whether a particular dispute is ripe for mediation, and if so, what are some of the special challenges or complexities the mediation might pose. At the very least, all the parties to the conflict have to be willing to participate.
We are all participating in mandatory fun activities.
Sometimes one party might be really keen and the other party might be a little bit wary or hesitant. In this pre-mediation phase, a mediator might reach out to a party that has a concern to hear what those concerns are, to address them, and to build rapport and trust. Sometimes you might discover that the situation just isn't right for mediation. And one experience I had during the intake, I was called by an elected official who asked me to mediate a situation where various staff people within a city department had complaints against their supervisor, but none of the people were willing to come forward in any way to describe or name the complaints, or meet with the supervisor, or even have the complaints anonymously shared with the supervisor.
It's quiet.
So I got to tell you, in this situation, I felt a little badly for the supervisor who has a bunch of workers complaining about them, but no one will actually come forward and have a conversation with that supervisor, but that's besides the point. So after listening and probing to see if I was missing something, I basically told the elected official that if there are not more than one party to the mediation, even if it were the city official herself standing in for the employees, frankly, there was nothing to mediate because a mediation requires at least two sides. So once the intake is complete, and assuming there are willing parties and issues to be mediated, then the mediation is scheduled. So not to get too meta here, but it turns out that the first step in a mediation process is describing the process itself, including the ground rules and the norms, etc. So as I elaborate, let me say that most mediators will design a process for a mediation based at least in part on what they learned coming out of that intake process. So what I'm describing in this video is what a process might look like in kind of general or generic terms. If you are ever involved in a mediation yourself, I expect that the mediator will tailor and adapt the process to the needs of the situation and to their own personal mediation style. So with this caveat, at the start of a mediation, the mediator introduces the parties to the mediation process, including the ground rules, expectations about confidentiality, the role of the mediator, and the possibility of individual caucuses with the mediator and when there'll be breaks. In this step, the mediator reminds the parties that they will be serving as a neutral third party, someone who has no decision-making authority and will not issue a ruling or an opinion in any way. In addition, they make it clear that they are the masters of the process, but will not weigh in on who is right or who is wrong. The mediator will also remind the parties that proceedings from the mediation are typically confidential. In most jurisdictions, what is discussed or shared in a mediation cannot later be used in a trial if the mediation fails. Mediators also have different views about whether all the parties ought to be in the same room throughout a mediation, for some period in the mediation, or sometimes not at all.
What are you doing? Get out of my room!
There's a lively debate within my field about the pros and cons of having parties be present in the room for the entire mediation. For the purposes of this video, I'm not diving into this morass. Suffice to say that one typical way of proceeding is that parties will largely be present in the room together, but at times a party may request an individual conference with the mediator, and at other times a mediator themselves may request an individual conference with one of the parties. Whatever process a particular mediator chooses, the mediator should make clear at the start of the mediation. My own personal preference when possible is to largely have all the parties present, but to set an expectation that at times I will meet privately with one of the parties, and that whenever I do that, I'll always give the other side a chance to meet privately with me as well. What's most important is that the parties understand what to expect so that they are not surprised when this happens. As part of this first step, a mediator will likely offer some suggested basic ground rules for the mediation. For example, the mediator may ask parties not to interrupt each other, and they will typically assure each side that they will have an opportunity to present their side of the story as they see it at the start of a mediation. Once these preliminaries are done, a mediator will usually invite each side to present their case or their version of what has brought them to the mediation table.
I rest my case.
When I'm mediating, I always remind the side not speaking that they'll have a chance to present their version without interruption as well. After each side has presented its story, a mediator will often try to extract some basic themes and interests from what they have heard. They do this to help frame the issues for the mediation, but also to make sure that that party has feel heard.
Just want to feel heard.
The mediator needs to do this with empathy, but here's the challenge. Without agreeing with any of the alleged facts presented, or with any of the merits of the arguments made by that person. Once both sides have presented their case, the mediator will typically have a clear articulation of both the issues and the interests of both sides. If they do not, the mediator will likely ask some clarifying questions. Once the mediator has done this, they will confirm both the issues to be discussed and then the interests of the parties with respect to these interests.
Okay, elephant in the room. Let's talk about it.
This is an opportunity for either or both parties to clarify, to add issues, or to elaborate on interests. The next stage is the opportunity for parties to use these lists as a way to start to brainstorm some possible options or ideas that could actually meet their interests. Again, depending on the nature of the dispute and the nature of the relationships between the parties, the mediator may set up a period of brainstorming where parties are asked to brainstorm ways to address the interests without making any commitments and without evaluating whether any of the ideas are good or bad or plausible or implausible. The purpose here is just to get the parties coming up with ideas and, importantly, doing something collaboratively together.
Okay, think of it as a team building exercise.
It's worth noting that this kind of activity is more important in situations where the parties will have an ongoing relationship with each other after the mediation. The simple activity of jointly working on some task together has the benefit of improving the relationship and demonstrating at least some capacity for joint problem solving. This stage of the mediation can be really challenging for the mediator. At times during the brainstorming process, parties start to get evaluative.
I would never agree to that.
Or,
That makes no sense.
part of the mediator's role here is to prevent this kind of negative evaluation because it stunts creativity. But the mediator also has to be careful to avoid evaluating options in the other direction. As a mediator, I know I've caught myself doing this. I'll say something like,
Wow, that idea would really meet a lot of both of your interests.
this kind of evaluation, even positive, done too early, actually could stymie some good ideas. So instead, a mediator wants to be encouraging generally, without evaluating any specific idea. For example, they might say, what great work you're both doing, or keep on generating the list, it's so good, we'll have so much to work with. Once you've generated a good list of possible ideas, it's time to get to the work of asking parties to consider what they like and don't like about the various ideas. In this stage, the mediator is working with parties to move from option generation to commitment. If the mediation is successful, the parties will arrive at general terms of agreement. Depending on the nature of a mediation, it's common for a mediator to then use those terms to create a written document to memorialize the agreement. The document itself is usually written in layman's terms, not in legal terms. However, it's written with sufficient clarity and specificity so that it can be translated into a legal document if that is required. The signing of the agreement usually marks the end of the mediation, although in fact, there is a crucial last remaining step. And this is implementation. A mediated agreement is only successful if the parties follow through on the terms to which they agreed. In some mediations I'm involved with, I will build in implementation steps and dates to increase the likelihood of compliance. In other situations, I'll simply encourage implementation and let the parties know I'm available should there be hiccups or issues down the road. And still in other situations, I might independently check in a few weeks or even a few months to see how things are working out.
You guys okay over there?
How a mediator handles implementation is a product both of their specific situation and their own style. In one situation involving a workplace conflict, part of the agreement involved ongoing coaching sessions with me for both parties for the first 3 months of implementation. And even though this is very specific to me, perhaps the most disappointing aspect of mediating has been those times when the parties reach an agreement, but then I hear through the grapevine that the deal fell apart.
Well, at least we tried.
It's for this reason that I have put more emphasis on implementation and follow-up in my own practice than perhaps other parties might do or other mediators might do. So as I close out this video, let me say again that each mediation is really unique. The steps I outlined above are a skeleton example of how a mediation might be structured, but there are mediations that go on for weeks and months that might really look nothing like this. Or a mediation that lasts for a few hours that really is just about a dollar amount and nothing more than that might really bear no resemblance to what I outlined. It's also the case that mediations are rarely as linear as what I just outlined here. Now that you know the steps in the mediation process, let me direct you to this video, how to improve your mediation skills. Having said all of this, I hope that now that you have made it to the end, mediation is less of a black box process to you than it was when we started. Of course, if you want to learn more about mediation, negotiation, and other conflict resolution processes, I hope you will keep watching here and consider taking some of the classes I offer at the Cambridge Negotiation Institute, or you could learn more about the work I do at bobbordone.com. I'm Bob Bordone. Thanks for watching, and let's keep negotiating together. There it is, improve your negotiation skills. Click the video now.